Welcome to the Personal Injury Law Show. This is a show that keeps you up to date with what's happening in the world of personal injuries and of importance to you, the viewer. My name's Tony Carbone. I'm a personal injury lawyer of 30 years' experience. With me tonight I've got Nunzio Tartaglia, a partner in a law firm in insurance law. Good evening, Nunz.
Evening, Tony. Viewers, welcome.
And Jessica Rosla, an insurance lawyer in a law firm. Good evening, Jess. How are you?
Good. How are you, Tony? Good evening. Evening, viewers.
Tonight, viewers, we've got a very interesting episode which updates you on public liability and insurance law.
But Tony, before we kick off, what's in the news?
Look, Nunz, there's a lot of old stories and news stories, but the one I want to start off with is with this WADA appeal, the International Commission into Anti-Doping's appealing this decision, Nunz. How do you feel about that?
Oh, everybody knows I'm close to this, being a pretty avid Essendon supporter, so I thought it was off the radar, but it's back on. So effectively, ASADA didn't appeal the judgment from the AFL Tribunal, but then WADA, who's the World Anti-Doping Authority, had a further 21 days to consider an appeal, and basically on the 11th hour they lodged an appeal with the Sport of Arbitration. So we're back on for another year.
Jess, what could possibly be any different in terms of additional evidence that WADA can present that ASADA couldn't have presented? In view of the fact that my view is, based on speaking to other people that know a bit about sports law, is that they're not going to have access to these witnesses again because the courts won't issue subpoenas because there's no jurisdiction.
Yeah, well, that's exactly right, Tony, and I think the same issues are going to arise when WADA consider the case because they're dealing with the same evidence. So I'd be surprised if they reached a different conclusion.
It's a new hearing though, Tony, so it's not just an appeal from the
I appreciate
old judgment,
that.
so it's a brand new hearing, which, look, I agree with you. I think that the evidence hasn't changed though.
What concerned the tribunal in the original decision was the fact that there was a lot of conjecture and speculation as to what documentation had been destroyed or wasn't in existence, but you can't convict someone on speculation. That's what I'm saying.
Look,
I really don't know where they're coming from.
I tend to agree with you. No, look, I think it's disappointing that ASADA CEO Ben McDevitt was pushing WADA to appeal because I thought if he thought ASADA had a good prospects of appeal, he should have appealed.
You know what would be a great episode if we can get him? McDevitt and Hurd. On either side. We have to try for
I think you have to split me up from McDevitt as well, to be honest.
Look, we'll come back to this. Viewers, we've got probably the worst case of flouting the road rules I've seen in my life, Nonce. You've got this idiot driving along. She's barely got safety gear on. Yep. She's only got a helmet, no gloves, no shoes, and she's texting 100 kilometres an hour. Jess, what's this all coming to?
It's pretty ludicrous, Tony. I mean, I appreciate drivers can get distracted, but this is deliberately taking your eyes off the road and being on a motorbike as well, where the risk of riding is just enhanced by probably 100% in that regard. So it's really scary to see. This
is like walking the plank, isn't it?
Look, it's almost comparable to that, Tony. And you know, she's got caught out because obviously a driver who was beside her, or a passenger, I think, was filming her on his mobile phone. And look, I think as you point out rightly, Tony, her number plates could almost be seen. So I think she's going to cop it.
By the way, viewers, at 60 kilometres an hour, every 2 seconds you're travelling 60 metres. So at 100, imagine how fast she's going. Jeez, that's crazy.
Yeah, that's right.
Anyway, I'll get back to this. This poor kid, playing on one of those slides, a slippery dip, lost his little finger.
Yeah, so poor little kid, he was playing the slide and his finger got caught between the slide and the metal bar, and unfortunately they couldn't reattach his finger. It was amputated, and proceedings have been issued, or soon to be issued, for basically against the council for not providing a safe premises. And I understand since that time they've filled the gap up.
Unfortunate circumstances, but I mean, the boy seems pretty brave, as his dad describes, having gone through what he's been through, and hopefully they get a good result for him, Tony.
Yeah, I'm sure they will.
Well, they've said that doesn't meet the Australian standards. If that's the case, I can't see why he shouldn't be entitled to some compensation.
This poor lady in a nursing home was burnt to death by a heater. What's the story here, Jess?
Yeah, this is really unfortunate circumstances, Tony. So Amelia, who's 74 years old, was in the Homewood Nursing Home in Hallam, and currently there's a coroner's investigation on investigating her death because she was found, like you said, burnt to death next to a heater, which they believe to be the cause of her burns.
So what do they do in these homes? They just put them in there and no one bothers to check them to see if they're okay?
Look, if these allegations are proven true, I've got to say this is horrific because it sounds like she was there for at least 6 hours and almost, like as you said, burnt to death, and they tried to pick her up and almost roll her over, and it's discussing the detail that they've gone into. And you'd have to think there's some merit in it when one of the staff members has been sacked over it. You'd have to think there's unfortunately there's a stench to it.
You would think so.
It's not good at all.
Yeah.
Apart from the family suing for nervous shock and whatever else they can sue for, don't you have an issue here that someone's going to be charged criminally for failing to do their job properly?
Oh, look, whether it can get to that burden, I'm not sure, but it all depends what the coroner finds. But look, I hate to say, but I think that this could be a fairly strong case for all their family members because, from what they mentioned about the funeral, it's been a hard time for the family. So, I think there'll be more to come on this one.
I think someone will be charged out of this.
Look, there's a possibility, Tony. Yeah.
All right, trampoline. This is one of your favourite topics, Nunz.
Yeah, look,
tell us a bit about this claims afoot.
So Bayswater electrician Travis Jackson has issued county court proceedings against Bounce Inc. Bounce is that sort of that activity. I'm not sure if you've ever been involved in where they're on trampolines and they're bouncing everywhere.
I feel like I'm getting trampolined every day. Let's keep going.
But in the course of obviously the activity, he's sort of fell on the metal or the padding with metal bar underneath it. He's seen that it wasn't appropriately padded, and he's issued proceedings. And look, I've had some experience with Bounce, and they defend things quite vigorously. So I don't think they'll roll over on this one.
And look, that's certainly what they've indicated here in the statement to the papers. So it'd be interesting to see what they say. That if he proves that the padding wasn't adequate, then I think there's proper grounds there.
Yeah, I agree.
Well, if he's fractured his right heel, which is a pretty hard part of bone, I mean, you'd think that it almost speaks for itself, doesn't it?
Look,
sort of.
Yeah, I think I agree with Jess. So he's raised a number of allegations. One, he wasn't advised on how to use a trampoline, which I don't think goes far because it is what it is. But I think if he can prove that the padding is not appropriate in the circumstances, considering that's the activity you get involved in, I think there could be an angle there.
Look, I think it's a good case.
Yeah.
Viewers, we've got to go to the sponsors break. Stay tuned. After the break, we're going to take up this issue of the current law in public liability. Viewers, welcome back to the show. We're going to give you an insurance update, but before that, there's this talk about TV renos on sparking more accidents because they're encouraging people to do all these home handyman jobs, and every man and his dog's getting up on ladders and trying to fix roofs and this and that. And apparently there's 3,500 falls per year, and of those there's quite a few deaths and a lot of serious injuries. Very few people come off a ladder and don't sustain some sort of a serious injury. Yeah,
it's a bit like the motorcycles. You're always going to sustain injury. And the issue is that, in the workplace, there's a lot of OH&S policies and they're doing the right thing in terms of protecting the person on the ladder. But at homes, all those do-it-yourself jobs, people not taking care for their safety, and the hospitals are sick of seeing them.
Yeah, well, they make it look easier, don't they, Jess?
Yeah.
They get on TV, bang, 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 before you know it, everything's up.
Yeah, that's right.
But, the average person doesn't know how to use a screwdriver, use a hammer,
Yeah,
nail gun.
let alone negotiate a
shoot
ladder
themselves
whilst
with the
doing
nail
all
guns.
that. Yeah.
But Tony, you probably do the same. You always come and tell us that you've
Up
done
on the
this
ladder.
on your property on the weekend.
Yeah, I nearly got electrocuted once because I've cut straight through the wire.
Well, there's our point. So you've got to be careful.
Lucky
with
there's
yours.
safety switches. I would have been barbecued 3 times already. Anyway, just one of the things they've been advocating, one of the doctors advocating bicycle helmets to prevent the really nasty head injuries that lead to death. But that's something we should
Look,
take up.
initially, when I read the article, I thought it was going a little bit too far. But you know what? Looking at the stats, it's not. And if it's going to save lives and
Yeah,
injuries,
I agree.
then I can't see why it's not useful.
It's amazing how much the helmet can really help, Jess.
Yeah, I mean, I think it reduces the chance of a head injury by at least half, they were saying, and that the force is reduced by about 75%. So it's pretty significant, and it's a simple measure.
All right, there's a news flash that bye-bye Bolam. The Bolam principle in England's gone. What does it mean, Jess?
So, Tony, the Bolam principle effectively stood for the fact that whether a doctor should warn a patient of a particular risk, and that was to be determined by a body of peers, effectively. So the court would look at what another doctor would do as opposed to whether a patient would consider that risk important.
And that issue about the risk being important to the patient, that's the law in Australia.
Yeah.
In the famous case of Rogers and Whittaker,
yeah.
where the lady lost her eyesight.
Yeah.
Where she wasn't advised that if a certain procedure was carried out, there was that slight chance that she could lose her sight, and she said she wouldn't have had the surgery.
That's right. And look, I think it's a good result in the UK. And basically now it's more patient-driven as opposed to doctor-driven. And you know, if the patient was going to attach significance to that, you know, that warning or that failure to warn, then it could be a viable case. So I think it's a good result.
Well, in Britain, the laws come up to date with Australia instead of being the other way around. In the case of Montgomery and Lanarkshire Health Board, 2015 decision, which is just recent. And that was one where it was about a birth. And what are the additional facts to that, Jess?
So in this case, Tony, it was a failure to warn case, and the individual in question here argued that the doctor hadn't warned her about a permanent shoulder condition that she could have developed as a result of having a normal delivery. And she gave evidence that if she'd known about it, she wouldn't have had that, and she would have gone through with the caesarean birth.
As opposed to a natural delivery.
Yep.
And so the child was born with this permanent damage to the shoulder.
Yep, that's right. And look, it's and, you know, I think if a patient was going to attach significance to that, then why shouldn't they be able to get compensated for it?
So the test is whether the patient attaches significance to a risk that you're advised of.
Yeah, and it's different if you know, like it was, you know, an operation that needs to be had, say for instance cancer treatment. Then you can't use that. But if it's something that you've got options, then I think it can be used.
Yeah.
So the last thing you need them to say is, "Oh, I'm not sure what I would have done if I had known."
That's right.
Yeah.
That's not going to work.
Yeah.
All right, let's keep moving. This is a very sad case, this one. Lena Carlton, Crest Hotel, Sydney, 2014 decision in New South Wales. Do you want to give us the facts, mate?
Yeah, this is a horrific case, and reading it, I was stunned, to be honest with you. So Mr. Lee, unfortunately, passed away when was, you know, with his wife, was in a car park. His wife got out of the car, and you know, as you do, just to, you know, she gets out, and then he directs back into the car spot. Reversing back, there was the evidence is that the car arrestor, you know, wasn't adequately placed, and also the barrier wasn't safe. He's basically gone through the barrier, and the car's gone over the edge.
Don't they normally have a concrete
death.
barrier on the ground
Yep.
so that the tyres hit?
Yep.
So you don't hit your car onto the
barrier.
other barrier.
Yeah.
Correct?
Yeah, in this case, I think the way it was set up was that there were potentially 2 barriers, and one of them had worn. So the client couldn't pick up on the resistance required, and the car went over, unfortunately.
So he's hit the barrier, it's broken away, and he's gone off the edge, and he dies in the fall.
Yeah, obviously dies in the fall, and Mrs. Lee, Michelle Lee, basically issued proceedings at the Supreme Court of New South Wales for obviously a nervous shock because seeing her husband pass away, which was horrific, and also, you know, for her loss of earnings and so forth. So, and it was a massive result.
Well, she brought this action under the Compensation to Relatives Act, 1897, New South Wales legislation.
Yeah.
Jess.
Yeah, so there were two causes of action, Tony. One was under the Act you just referred to, where it's effectively a dependency claim, where she asked for damages in relation to what she would have lost and what her husband would have been able to contribute to the family home had he still been around.
Sounds to me that she was a bigger earner than he was, Nunz.
Well, she was a budding speech pathologist, so she had a big career ahead of her, which, you know, and the evidence is that she's been totally distraught as a result of his death,
She became suicidal.
Yeah, and basically, you know, unemployable now. So that's hence why the damages, Tony, was $2.9 million.
And do we have any idea what she was earning?
No, look,
would have been potential future earnings.
Yeah, she'd be on
right.
high. I would have thought fairly high money, and they would have to project what she would have earned, you know, once she got to her full level of, you know, hierarchy in her field.
And what was he doing, Jess, for work?
Mr. Lee was a support analyst, so they estimated Mr. Lee's salary at the time he passed, unfortunately, and also projected his future promotion. So there was a very methodological approach in terms of how they assessed his.
So between the
future
two of
life.
them, they were earning good
A
money,
fair
weren't
income,
they?
yeah. I think it's worth noting here the council was also implicated in this case, Tony, and the judge was very scathing as to his comments of the council's conduct. So what they said was that the council issued a building certificate, even having known that it wasn't compliant with the requirements.
Yeah, well, it was in breach of the Local Government Act 1919.
Yeah, that's right.
Yeah,
and
yeah.
notwithstanding, they still issued that certificate. So he described their conduct as unreasonable and negligent, which were very strong terms to describe for a council.
The court awarded $2.9 million, but after a break, we're going to tell you how much the court took off for Mr. Lee's contributory negligence, which I find astounding. Jules, welcome back to the show. Now, this Mr. Lee, his wife had her damages reduced by 20%. What does that mean, Nunz?
So effectively, the result was a verdict of $2.9 million, and the court discounted that or reduced that by effectively just under $600,000, Tony.
Because the court said that was a contribution by Mr. Lee to his own demise.
Yeah, that's correct, Tony.
So he must have been going pretty fast on the evidence.
Yeah, look, it seems that there was some evidence in that regard, but I still think 20% is a little high given the circumstances of this case.
Still a little bit mystified as to he must have really been travelling.
Tony, look, I tend to agree. Look, he must have been going a little bit quicker than the usual person would, but at the same time, you know, usually you feel yourself hitting something, but he must have just came off that quickly that it must be inherently unsafe that a car.
I'm very, very sympathetic to his cause and the family, but it sounds to me that he's hit the barrier. You would have sort of felt that, surely. Yes, no?
Yes,
We
I
don't know
agree
if the
with you.
radio was on, who knows? But then you would have thought you hit the barrier, you brake. I reckon he hit the accelerator by accident, who knows?
But even then, though, you think there'd be a bit of space between hitting the barrier and then coming off the edge. Like
That's because they've
You would
got
think.
nothing on the ground to stop the tyres from progressing any further.
hence why I think it's
Yeah,
not his fault.
yeah.
I think that 20% was a bit harsh. I think,
Yeah, I
maybe
agree.
5, if anything. But,
Yeah.
you know, that's probably because it's such a sad case anyway.
It is a sad case. All right, tell us about Dylan and Hare, New South Wales 2014. Jess, and this is very important to occupiers, owners of properties, invitees, just people in general coming in and out of properties.
Yeah, that's right. So this, I guess the message in this case is relevant to all homeowners effectively. So in this matter, a tenant had vacated the property and given notice and had asked the real estate agent to ask the owners of the property to prune the trees effectively, to make room for the removalists travelling in and out. She then goes back to the property and it was discovered that the homeowners attended to the pruning themselves. And when she attends, she realises a mat had been placed at the door, Tony, so on the inside
is
of
normal.
the property. And she's figured, oh, they've placed it there to avoid dirt going in and out as the removalists come in. Makes sense.
Something to wipe your feet
Yeah,
on.
a lot of people would do that. Unfortunately, at the final inspection, the real estate agent attends with the tenant. They walk through the house, the tenant walks out, the real estate agent walks out and then slips over the mat and falls onto her knee.
The mat moves.
The mat moves, yeah.
And she's badly
Falls straight
damaged
onto
her left knee.
That's correct, yeah.
Yep. Nons, what the court find?
Margaret Hare issued proceedings against both the owners of the property, the Dillons, and also the tenant, which I thought was interesting. And look, she was awarded just under $214,000, and it was on appeal, and she was successful on appeal as well. But interestingly, all the liability was attached to the owners and not the tenant, which I think was the right outcome.
Yeah, I would have thought so. Look,
the tenant had no. She didn't put it there. She only saw it on the day that she got back. I don't see why she was to blame.
Yeah.
No.
I think in a strict sense, it made sense to me to have the tenant in as effectively an occupier. But I agree with you, when you break it down, she had no involvement in the matter at all. And
there was also evidence that this was a very old mat and that the rubber underneath had worn away.
Yeah, and I think the floorboards had been recently polished.
Yeah, so and it was on polished floorboards.
And no non-slip backing. So look, there was cheap ways to avoiding this accident, and I think that's why the court, I think ultimately found for Margaret Hare. But
so what the court said was it was a foreseeable risk that was not insignificant in the circumstance for a reasonable person to take precautions to prevent the accident from happening. So this is a warning to all homeowners and anyone that's occupier of a building to ensure that if you place mats on the ground or anything that you might do on a property, if you can reasonably foresee that someone can get injured, you've got to take reasonable precautions. Is that
exactly
correct?
right. Exactly right, Tony.
All right. Now, this is one that I'm not really happy about, but Metaxulus and McDonald's Australia Limited, 2015 New South Wales decision. Geez, they're very litigious up there, aren't they?
Yeah, well, the 3 or 4 that we're discussing tonight are all from New South Wales, so they love litigating. There's no doubt about that. And this is another one which went to New South Wales Court of Appeal, and the plaintiff was successful on appeal, Tony. It's a strange case, to be honest with you. So effectively, the plaintiff was injured. Basically, there was a gate where no one was allowed to go or should be locked. And kids at this McDonald's site got through there. Was on the playground or the play site. Got stuck on the playground. Mr. Metaxulus, he tried to assist, got the child off, gave it to somebody else, and when he was coming down, he slipped and fell and injured himself. And he sued McDonald's for basically allowing that gate to be unlocked or be opened or have access to.
And Jess, what did the court find?
So look, the court found in the plaintiff's favour on both occasions and awarded damages in his favour. So they considered that it was foreseeable to McDonald's that the gate, when open, kids could easily climb through that area, which occurred in this case, and that there were other aspects or measures they could have taken. So have a self-hinging gate or an automatic locking gate or the like. So ultimately they found in his favour and awarded damages for pain and suffering and economic loss in this case, Tony.
Well, and the court went on to say that a reasonable person would have taken precautions which might have included placing a warning notice or mounting a lock on the gate or spring-loaded hinges. So it's not much to do, really, is it?
No, it's a cheap way to avoiding it, but I'm still a little bit confused as to it's a playground and the kids are on the playground, and I don't see how the gate was a big issue in that. That's what I'm still struggling to find.
That's what I'm saying. It was an interesting decision.
Yeah, I think there must be more to it than what obviously we've been aware of.
Jess, Liverpool Catholic Club, very brief on this one because I don't like the result, versus more 2014 New South Wales again.
Yep.
Skating. This person's injured themselves on a skate ice rink.
Yeah, so the facts of this case, Tony, are such that the person was walking down the steps to access the skating rink, and he did so wearing his skating shoes, which are quite large and awkward to walk in. So as he's traversing the steps to go down, he slips and falls, which I suppose is expected. He was successful at first instance, but then was unsuccessful on appeal.
That's
So
extraordinary.
Look, I share the same opinion as you do. But basically, the court found there was an obvious risk, Tony, that you should be aware of the risk that posed, and to that end, they don't need to warn.
Yeah.
Bad decision. Considering considering the one prior to that, where really I agree with you, this one was a bit better case on the facts.
Oh, well, yeah, Jess and I have a different opinion on this
Yeah.
one too. So
Anyway.
that can be a discussion for another day.
We've reached the end of the show. Jess, thanks for coming on board. Nunz,
Thanks for
thanks for
having
being
Thanks, Eddie.
part of the show again. Viewers, thanks for watching. Stay tuned for future episodes. Go to our past episodes. Go to our social media websites, Facebook, Twitter, and all those other lovely sites. And always remember to stay safe.